All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for segment 3 of our strategic advocacy across courts, agencies, and the Legislature CLE series. This segment is distinctions between the law, legislative intent, and application of law. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered for this training, you're going to receive an email from Zoom within about 24 hours. That email is going to include a link to the recording, a link to the materials, the CLE code. And if for whatever reason you didn't register, you can also find it on YouTube. We will be posting it within about probably 24 hours as well. We will also be updating the PILS website where you can find this segment, the previous two segments, and the link to register for the last segment happening at the end of the month. So this training was approved by the Florida Bar for multiple CLE credits. A lot of credit goes to Viletta for helping me out with the agenda and making sure we were maximizing our credit. This one was approved for one general CLE credit, for one state and federal government and admin practice certification credit, zero point 0.5 professionalism credit, and zero point 0.5 ethics credits. I am working on trying to get some additional credit for appellate practice that I might have to get approval, and I'll update everybody if I do get that additional CLE credit. And one important note about this CLE series as a whole, we have 4 segments, and if you watch all 4, this is the third one, but if you watch all 4, with 4 CLEs, you're going to get 2 CLEs for professionalism and 2 CLE credits for ethics. So it's a great bundle and a great topic to have. So as I said, I'll announce the CLE code towards the end. I will drop it into the chat. I'm pretty sure it's in the slides as well. And if for whatever reason you miss out on it, you will find it in the YouTube description, and it will also go out on the email that Zoom sends out. So closed captions are enabled for anybody who needs them. So if you're having any issues with audio, accessibility, captions, feel free to let me know. I will also drop my email into the chat. And really important here, this training is being co-hosted by the Public Interest Law section, or PILS, and the Admin Law section, PALS. So together we are PALS. I can't get tired of saying that. It's just easier to do it. Maybe we need to do a merged version of our section. So both of our sections are pretty great. I'm going to include a lot of links in the chat so you can look at our websites, you can look at our membership benefits. I'm also going to include all of our social media links so you can follow and subscribe and do all that good stuff. So if you're not a member, please consider taking a look at both sections to look at their benefits. And there are a lot of perks, a lot of great substantive work groups and operating committees. So please take a look at those sites. So final piece of housekeeping announcements are questions and answers. We're going to ask you to hold your questions towards the end. You're going to be able to use the chat or the Q&A, but we know you will probably have questions. Be on the lookout because we do have one interactive poll during the session. So we are looking forward to participation. So with all of that said, I'm going to go ahead and quickly introduce our speakers. If you want to read their full bios, they're going to be available in the material. I'm going to start with Bradley Butler. Bradley is a Florida Bar board certified attorney in state and federal government and admin practice, and currently serves as a senior attorney with the Florida Agency for Healthcare Administration. Mr. Butler has previously worked with the Florida Department of Health, Office of Medical Marijuana Use, and the Florida Department of Environmental Protection, and the Florida House of Representatives. He earned his Juris Doctor cum laude from Stetson University College of Law. Mr. Butler has presented on negotiated rulemaking at the 2025 PAD-DOR conference and post-hearing practice at the 2024 practicing before DOAH CLE. Viletta Coombs, welcome back, Viletta. If you've been attending these, you've noticed that Viletta is going to be on at every segment. So Viletta Coombs is a Florida bar attorney with more than 20 years of experience in admin, legislative, and litigation advocacy. She has dedicated much of her career to public interest work with Florida Legal Services and multiple Florida state agencies, focusing on serving vulnerable children and families. Viletta is also an experienced trainer, presenter, and leadership development professional. So without further ado, it is my absolute pleasure to pass it over to our amazing speakers, Viletta and Bradley. The floor is yours.
Jorge, thank you so much for the introductions and all of the housekeeping information. We sincerely appreciate it. We're super happy to be here. This is the Strategic Advocacy Across Courts, Agencies, and the Legislature CLE series. presented by myself, Viletta Coombs, and Bradley Butler Jr. I have a disclaimer. The content of the CLE, as well as the views and opinions expressed by the CLE presenters, do not reflect the views of current nor former employers, including but not limited to Florida State University, Florida courts, Florida agencies, and the Florida Bar. The presenters' views are their own and not legal advice. The presentation of this information does not form an attorney-client relationship. This information is for educational purposes only. Welcome to segment 3, Law versus Legislative Intent. And before I begin, I'd like to give a special thank you to the Public Interest Law section and the Administrative Law section of the Florida Bar and the Florida Legal Services Statewide Training Initiative for sponsoring the CLE series. Thank you so much. We'll begin now with our Part 1 case study of a RAC appeal. The following case study is based on factual events between 2010 and 2011. Factual events pertain to the Unemployment Compensation Appeal with the Unemployment Appeals Commission, now known as the Reemployment Assistance Appeals Commission, which is why we'll refer to it as RAC, and everything thereafter. For the purposes of the case study, this incident takes place in Marshland, a fictitious state that follows Florida law and mirrors Florida's system of government, executive, legislative, and judicial. We're back now here at Marshland Academy. On November 11, there was an incident at Marshland Academy involving a 5th grade student named Mandy Magpie. Her date of birth is 11/11/2000. Mandy removed a 5-foot 6-pound ball python from the classroom aquarium without permission and supervision from her teacher, Mr. Swamps. Patty the python slithered out of the classroom and into the main hallway. When students encountered Patty in the main hallway, it resulted in a stampede in which numerous students were injured and transported to the hospital. As a result, Mandy was charged with disruption under Section 877.13 Florida statutes. In Mandy's own words, "I knew lunchtime was my chance to rescue and free Patty from the classroom aquarium. You see, I recently read an article in the Mighty Marsh blog about protecting animals in their natural habitat. I knew that Patty came to Marshland Academy as an egg and grew up here in captivity. I thought she may want to be free to find other ball pythons to live with them. I did not mean to hurt Patty or anyone at the academy. I just wanted to be a good student and protect animals and our environment. I am sorry that many students were hurt in the stampede. I've received punishment from parents, no social media, and cancellation of my junior memberships in activist groups. Mr. Swamps, a 1,000-word essay on actions and consequences, and the Academy, temporary suspension and cancellation of the Academy Nature Club, which I started. I enjoy splashing in the mud, reading, working with animals, and preserving our environment. And when I grow up, I want to be a zoologist, a veterinarian, a park ranger, or a pop star. Because after all, she's like 11. Unfortunately, we're at Mr. Swamp's unemployment appeal. Following the incident with Mandy Magpie, Patty the python, and student injuries resulting from the stampede of students in the school hallway, Mr. Swamps was suspended from his teaching position, and shortly thereafter, he was terminated from his teaching position. And by the way, Patty the python was the principal's pet. Mr. Swamps had no control over Patty being assigned to Mr. Swamp's classroom. Now Mr. Swamps is going to file his appeal. Mr. Swamps timely filed a claim for reemployment assistance benefits, formerly known as unemployment compensation benefits. Mr. Swamp's claim was denied. He timely filed an appeal. At his appeal hearing, the appeals referee agreed with the original determination, denial of benefits. Mr. Swamps timely filed an appeal with the Reemployment Assistance Appeals Commission, RAC. Upon review of the record, RAC issued a final order upholding the appeal referee's determination, denial of benefits. Mr. Swamps, a resident of Bog County, Marshland, timely filed an appeal of the RAC's final order with the Marshland Second District Court of Appeal. And the second DCA transferred Mr. Swamp's appeal to the first DCA. Now we're going to talk just a little bit about clarifying, interpreting, or challenging existing law. In this scenario, you represent Mr. Swamps and his appeal to the second DCA. You don't understand why the second DCA transferred the appeal to the first DCA. So you review the statute, section 443.1514E of Florida statutes. This is now the year 2010. So we're looking at this version of the statute, and the year is very important. Judicial review. Orders of the commission entered under paragraph C are subject to review only by notice of appeal in the District Court of Appeal in the appellate district in which the issues involved were decided by an appeals referee. This is the most important part. In the appellate district in which the issues involved were decided by an appeals referee. You don't understand why the second DCA transferred his case to the first DCA. And you're starting to realize this issue is bigger than Mr. Swamps. As you review the statute and case law and public records, you begin to understand there are conflicting DCA opinions regarding the proper venue, specifically really the proper forum for RAC appeals, as discussed in segment 2 of the SIII series. The forum for RAC appeals impacts Mr. Swamps as well as all unemployment claimants. And now that's really got you thinking, this case now has the potential to become a test case, regardless of which DCA's opinion ultimately prevails. When put to the test, this case will create precedent that will impact all RAC future appeals. Remember the advocacy strategy as discussed in segment 1 and segment 2 of this SIII series. You identify the issue. In our case, it's that the second DCA transferred his appeal to the first DCA. He developed a legal strategy using administrative, legislative, or litigation advocacy, or a combination thereof. And then if needed, you identify the perfect client to pursue the issue. In an ideal world, you could be strategic in choosing the right person, entity, case, etc., with beneficial facts, location, and timing. In this instance, it's Mr. Swamps. This wasn't a planned test case. This is more of an unintentional test case. And then as you look at this, you want to think about the impact. The outcome impacts all people or entities with that issue. So in this instance, the outcome would impact all people and entities that have unemployment appeals, similarly situated to Mr. Swamps. So this is a systemic issue, and the outcome has the potential to result in systemic change. Now I will ask Brad to talk about challenging the District Court of Appeal.
Thank you, Vi. So when we are presented with this case, first thing we want to do is take a look at what the District Court of Appeals said when they're transferring the case. So let's pull up the transfer order, and when we look up this second DCA order transferring Mr. Swamp's appeal to the first DCA, it states, since this court issued the Lynch v. Unemployment Appeals Commission decision, which was 988 Southern 2nd District 25 from March 2nd DCA 2008, we have routinely transferred such appeals, unemployment compensation appeals, to the first DCA. Using a letter of transfer in accordance with the requirements of Florida Rule of Appellate Procedure 9.040 sub B1. See also Article 5, Section 2A of the Florida Constitution, which talks about the territorial jurisdiction of the courts. In these cases, we transfer the notice of appeal to the first CCA without opening a formal appellate proceeding in this court. Now, doesn't that sound a little bit odd? Can a court do that? Transfer without opening formal proceedings, without even issuing an order to show cause why it shouldn't be transferred? This also means you really can't track where an original RAC appeal was filed. If a court is transferring a case without formal proceedings, without an order, it could very well have no history showing where it was prior to arriving in the first CCA. So as we look a little bit further into these rules that are cited by this transfer order, looking closer at Rule 9.040B1, it states that if a proceeding is commenced in an inappropriate court, that court will transfer the cause to an appropriate court. Well, it does seem that's what the second DCA is doing, but the question is was the second DCA an inappropriate court? That is a question that I don't think we necessarily agree with right now in our as Mr. Swamp's counsel, so we're going to try to look a little bit deeper into that. Looking into Article 5, 2A of the Florida Constitution, it states that the Supreme Court shall adopt rules for the practice and procedure in all courts, including the time for seeking appellate review, the administrative supervision of all courts, the transfer to the court having jurisdiction of any proceeding when the jurisdiction of another court has been improvidently invoked. So what that means is that ultimately the Supreme Court is the one laying down the rules that the DCAs will be following in this situation, including the Rule 9.040B1. These rules are issued by the Supreme Court through orders, and then the lower courts are expected to follow them. But as we dig deeper into the Lynch decision, we notice that the Lynch decision isn't really based on Rule 9.040, but rather, if we look at Section 443.1514E, the Lynch decision appears to be basing itself on this section of statute. In the Lynch decision, the court talks about, with some reluctance, this court has concluded that the legislature has not authorized it to handle this appeal. Technically, we may have jurisdiction, it says, over such an appeal, but the first district is the court by statute that is the proper forum to decide this case. It then continues on in the Lynch decision discussing venue and talking about whether venue is an appropriate term for this. The rules speak specifically as this is a forum provision rather than venue to avoid the personal jurisdiction entanglements that the term venue comes from. At the same time, it does appear more that this statute and that the Second District Court of Appeal is applying more of a venue provision, saying that it doesn't really matter which court reviews it, they'll be applying the law that is in the certain area like venue would. But with choice of law provisions, we're generally dealing with different jurisdictions. We're not dealing with two Florida jurisdictions. District courts of appeals should not have differing interpretations of the same statute. It's when we have some of these issues that the Supreme Court needs to get involved. One question, though, that might appear in your mind, though, is transferring all RAC appeals to the first DCA under the guise of having been misfiled in all other DCAs is a practice that's not codified in statute or rule. Now, a state practice that is not codified in action or in statute or rule that interprets or prescribes practice requirements might be considered a rule, and a rule that's not promulgated would potentially be an unadopted rule. Now, is this action by the DCA an action that's based upon an unpromulgated rule? We'll get back to that in a little bit, but I want you to think about it and maybe think about in your head, do you think this might be an unpromulgated rule or maybe not? We'll talk about it in a later section now. Moving on, though, let's look a little bit deeper into the Lynch decision, see if we can find some things that can help us to both expand upon what we would like to do, which is keep it in the second DCA, and potentially find out if there are any tools that the Lynch decision gives us to effectuate that result. So the Lynch court had three very important statements that I believe hold great weight. The first one is the second DCA agrees that technically, as in according to Florida Constitution and other statute, it would have jurisdiction over this appeal. However, another statute, 443-151, provides that the forum is only proper in the first DCA. The Lynch decision arrives at this determination by taking a very strict look at the statute. Now, if we look over in Section 440, which is one of the statutes that the Lynch decision talks about, the section, Chapter 440's workers' appeals has a specific explicit statement that all of those appeals will happen in the first District Court of Appeals. 443-151 does not have that same specific statement. Instead, they have the statement that we looked at earlier, which says the appellate district in which the issues involved were decided by an appeals referee. It doesn't explicitly say first district appeal, so that's our first thing that we can look at as a difference between the two statutes that Lynch is talking about. The second DCA also points out that the third DCA disagrees with this reasoning in another case, Mendel v. Dade County, which is 574 Southern 2nd District 195. In Mendelman, the third DCA interpreted 443-151 to provide forum in any DCA with territorial jurisdiction over a location which a party participated in the hearing. The Mendelman decision talked about practicality concerns. The Mendelman case was taken over a phone. They had multiple parties in different areas, and they believed that practically it made sense for people to appeal in the district where they resided and not have to force them to go to Tallahassee, especially if, for instance, in Mendelman v. Dade County, it was occurring in Miami, which is a 7-hour drive from Miami to Tallahassee. The second DCA also had a third statement that is very, very great to have in any case that you want to bring to the Supreme Court, and that is a certification statement. We certify that our decision today is in express and direct conflict with the holding in Mendelman. These are the golden words. For any attorney hoping to build a test case, you are hoping the DCA will certify their decision in direct and express conflict if you lose. Hopefully, obviously, you're hoping to win, but if you lose, you want a certification that there's an express and direct conflict with the holding of another DCA. The Florida Constitution, Article 5, Section 3, subsection B4 states that the Supreme Court may review any decision of a District Court of Appeal that is certified by it to be in direct conflict with a decision of another district. With these golden rules, we learned that our only course of action is to appeal to the Marshland Supreme Court. Armed with our reasoning, armed with Mendelman, and the practicality concerns that we shall take our test case regarding the second DCA's application of the appeals process in Chapter 440 to the appeals process in Chapter 443 Florida statutes to the Supreme Courts. But there is a question. Is this really our only course of action? Legally, yes. But from a strategic advocacy perspective, there might be other avenues. And I'd like to pass it over to Vi to talk about the next section.
Thank you, Brad. I appreciate that. So now that we've learned that we have an option of appealing to the Florida Supreme Court, let's take a look at legislative intent. See, the second DCA is taking the workers' comp statute and applying that to the unemployment compensation statute. So let's go over it. Workers' compensation is governed by Chapter 440 of the Florida statutes, pursuant to 440.271 Florida statutes, and even though it's 2010, it was completed in 2008. Appeal of order of a judge of compensation claims. So review of any order of a judge of workers' compensation claims entered pursuant to this chapter shall appeal to the District Court of Appeal, First District. That's very specific. Very specific. By appeal to the District Court of Appeal, First District. Now let's move to an entirely different chapter, which is 443, Florida statutes. Pursuant to section 443.151, 4E, Florida statutes 2010, the year is important. Orders of the commission entered under paragraph C are subject to review only by notice of appeal in the District Court of Appeal in the appellate district in which the issues involved were decided by an appeals referee. The Marshland Legislature is very specific. The District Court of Appeals where the issues involved were decided by the appeals referee. 443 does not reference a specific DCA like the workers' comp statute does. 443 does not reference or allude or imply or anything with regard to Chapter 440, but yet the second DCA applied 440 to 443. The workers' compensation and unemployment compensation are governed by two different chapters and two different processes for appeals. Now, while it's fruit because it's appellate, we're not apples to apples and we're not oranges to oranges. And it begs to question, how is it that from no other basis, the second DCA took 440, that appellate process, and just applied it to 443, saying that it's in the spirit of the law, but the statute doesn't at all speak to that. Well, if we're looking at legislative intent, think about this. At the time that Chapter 443 was drafted, unemployment compensation appeal hearings were conducted in person. Offices were operating in brick and mortar. Now, when you fast forward to 2010, we have changes in technology and changes in process. Unemployment compensation appeal hearings are now conducted via phone. So, in short, the process for hearings changed based on the practices of the state agency. However, the statute was not updated to reflect current practices of the agency governing the federal unemployment insurance program. I think you can appreciate the difference because we're experiencing this right now in real time. For Mr. Swamps, back in 2010, the way the statute was drafted, everyone was in person. So the thought would be that you would appeal to the appellate district in which the appeals referee made the decision because you would have seen the appeals referee in person local to you. However, by 2010, they're conducting the hearings by phone, which means the appeals referee could be anywhere in the state of Marshland. You can relate to this now because right now we've gone virtual. Most and many of our hearings that we conduct are really conducted via Zoom, which means that people can be in any number of places within the state or outside of the state of Marshland, correct? So we are also in the process of actually updating our laws and our rules to reflect our current practices in how we actually conduct our hearings, our business, all of our judicial administration. We'll be getting rules with respect to virtual hearings specifically. We'll be getting rules updated and statutes updated with respect to AI. Things change. The statute needed to change. So it was never the intent of the Marshland Legislature to send all RAC appeals to the first DCA. That is why the agency, with push and pull factors created by Mr. Swamp's case, pursued a legislative fix, a legislative remedy. The result is the 2011 statute update as illustrated in comparison below. All right, I told you the year was important. Let's compare 2010 to 2011. 2010, orders of the commission entered under paragraph C are subject to review only by notice of appeal in the District Court of Appeal in the appellate district in which issues involved were decided by an appeals referee. That's your limit, the district in which the issues were decided by the appeals referee. Now let's go to 2011. Orders of the commission entered under paragraph C are subject to review only by notice of appeal in the District Court of Appeal in the appellate district in which the claimant resides, or the job separation arose, or in the appellate district where the order was issued. Do you see the difference? There's no mention of the first DCA. The first DCA has nothing to do with this. At the time, we had 5 DCAs. Now we have 6 DCAs. There's no reason to transfer all RAC appeals to one DCA. What would be the purpose of having 6? And in this instance, you're given your advocacy strategy, because not only was there legislation in terms of advocacy, there was litigation and administrative advocacy as well. You had the option of pursuing this through your appeal to the Marshland Supreme Court, but you also had the option of pursuing this through a legislative remedy that is consistent with legislative intent, that is consistent with how we did business at the time the statute was drafted, and it just needed an update. And it's kind of beautiful because it's one of the few times that you can go hand in hand with your opposing counsel and skip over to the legislature and say, hey, we have a problem. The agency didn't do anything wrong. No one's at fault. It's just that the statute isn't consistent with the legislative intent and doesn't reflect how we do our business now and our current practices. All we need to do is update it, and that'll fix it. Easy peasy. I know we wish they were all the time, but in this instance, the issue was easy peasy, so to speak. And at this time, we're going to go ahead and do our ethics poll. Okay, the poll is visible to you, and I believe all of the language is there. Maybe we didn't exceed our character limit this time, but answer based on the poll as it appears in the slide. You represent Mr. Swamps and his unemployment compensation claim against the Academy. The Academy wants you to represent them against a negligence lawsuit filed by the parents of students that were hospitalized as a result of the hallway stampede. What is your ethical duty? 1, do nothing. You have no ethical duty to your new client or a former client. 2, determine if there is a conflict in representing the new client considering your representation of the former client. If so, rescind representation. 3, tell the new client about the former client's unemployment compensation proceeding. Talk to the new client about the conflict. Ask the new client if they're interested in proceeding with you as counsel, and if so, are they willing to sign a conflict waiver? 4, contact the previous client, explain the details of the new client's case, and request a waiver to represent the new client. Please vote now.
I think this is an interesting one, Vi, because we're constantly dealing with ethical issues like this in our normal everyday practice.
Right.
It doesn't seem like an unemployment compensation claim and a negligence lawsuit are going to be too similar, but I think you can see some reasons why there could be some conflicts.
Absolutely.
All right, so we're at like 50% participation. Let's get everybody maybe a few more seconds, maybe a minute. I see more answers coming in.
Okay.
I'm like in between. I can't answer as a host, but I'm struggling to decide between 2 and 3, to be honest. And I don't want to get it wrong. So I'm going to just hold my silence.
They were purposely drafted this way where they're all pretty close, and we're going to walk through each one.
Absolutely.
Right,
And then do we have a finalization?
We have 56%. I don't see any more answers coming in, so I'm going to end it in 5, 4, 3, 2, 1, ending the poll and sharing the results.
All right.
Oh, this is awesome. Okay, Brad, I'm going to let you take the lead on this one.
All right.
This is great.
All right. So first things first, thankfully, nobody decided choice number 1, do nothing. You have no ethical duty to your new client or former client. I think we all know that's not true. We all have ethical duties to new clients, to former clients, to prospective clients. What the range of those ethical duties may change, but we always have an ethical duty to our clients. The second one, determine if there is a conflict in representing the new client. considering the representation of the former client? If so, rescind representation. So you've got to decide, is there a conflict between your new client and your former client? And if there is a conflict, rescinding representation of the new client, because obviously you can't rescind representation of a former client. It's already happened. I think that this probably encapsulates the best review of your ethical duties, because you have to have your ethical consideration on your own. You really can't talk to your clients about the ethical duties, because then you might be breaching your ethical duty, especially if you're telling a client about a different client, which we'll get to in 3 and 4. So this is probably the best encapsulation of what you can do. You can potentially talk to other attorneys, especially if they're in your practice, about ethics, and there is the ethics bar hotline if you have an ethics question, but you can't talk to clients. And as we get into questions 3 and 4, so 3, tell the new client about the former client's unemployment compensation proceeding. This is a big no-no. You cannot reveal information about a former client's case to a new client. You're breaking your ethical duty to your former client when you're doing that. So even if you talk to the new client about the conflict and get a bunch of information, make sure they're happy with proceeding. You've now broken an ethical duty to your former client by revealing what could potentially be confidential information to a new client. And for the same reason, number 4 is incorrect. If you contact the previous client and you explain the details of the new client's case, you're now breaking the ethical duty to your prospective client, your potential new client. You have an ethical duty to prospective clients just to the same level as you do with new and with former clients. It's not going to have the same rules, because obviously a prospective client is not a client that you may take on, and so you may not have the same levels of duty, but you still have an ethical duty to them, and you can't betray that ethical duty by providing details that might be provided to you in confidence to anybody, a new client, an old client, anybody. So I think we had 52% choose number 2, so over half of you got the right answer.
And it was intentionally difficult. I have to add, it was definitely intentionally difficult. But I also want to say, no matter how many waivers you get signed, you have to ask yourself, is this going to be enough? Do you feel
Mm-hmm.
safe with the waiver? Or if you have to defend your position or defend the fact that you represented someone, and sometimes it's just not going to feel safe to do it, no matter how many waivers you get signed.
Yeah, and the waiver process definitely has a lot of problems with it, because you do have to. There is a little bit of explanation that you've got to give, but you have to be very good about not talking about confidence. Waivers really work when you have clients that are already aligned together. Like, for instance, defendants in a lawsuit. That makes sense to have waivers between the defendants sometimes, but for very distinct clients, a waiver is probably not your best course of action.
Things to remember, definitely things to remember.
Yeah.
And now we'll move on to our next section specifically with Brad.
All right. So I asked you guys earlier to think about unpromulgated rules and the rule that we were talking about with the second DCA. So those of you who thought this was an unpromulgated rule, we're not going to do a poll, but those of you who thought that the second DCA's decision to transfer the RAC appeals to the first DCA without any particular statute or rule, it is not an unpromulgated rule. And the reason why it's not an unpromulgated rule is because the second DCA is not an agency of the state of Florida. The second DCA is codified underneath the judicial branch under Article 5. And all rules for the judicial branch are done by the Supreme Court of Florida. They're not done by an agency. So we're not. So the second DCA would not be interpreting or prescribing an agency rule. They would be interpreting or prescribing a Supreme Court order, which is the province of the second DCA. So it's not an unpromulgated rule, but there are unpromulgated rules that we do have to consider. Under Section 123.536 Florida statutes, a grant of rulemaking authority is necessary but not sufficient to allow an agency to adopt a rule. A specific law to be implemented is also required, and an agency may adopt only rules that implement or interpret the specific powers and duties granted by the enabling statute. Under Section 125.220, the definition of an unadopted or unpromulgated rule means an agency statement that meets the definition of the term rule, but that has not been adopted pursuant to the requirements of 125.4. So this is our basis for our understanding of unpromulgated rules. We'll go into the definition of 125.2, I think it's 8 for invalid delegation, and then rule itself is also defined within 125.2. So let's move on to our next little case involved, the Marshland Nature Club. So Marshland Academy, following the instance with Patty the Python, banned the Marshland Academy Nature Club following Mandy's suspension. Mandy decided she's going to start her own independent Marshland Nature Club to care for Patty the Python. Marshland Animal Control, however, Marshland Animal Control, after capturing Patty at the school, delivered Patty to Mandy's family. Well, the Marshland Fish and Wildlife Conservation Commission, the commission, learned about Patty and sent Mandy a notice informing her that Patty is a non-native species, and an adult was required to apply for a non-native species permit to keep Patty. Otherwise, Patty would be euthanized. Mandy's Nature Club is very, very sad about this and wants to challenge the commission's position because Patty is not on the prohibited non-native species list under Chapter 68.5 Florida Administrative Code. So what is Patty going to do? Well, Patty has come to us for help. She is, after she finishes... Mandy, oh, sorry. Yes, Patty doesn't come to... Although she might be euthanized, Mandy is the one who comes to us for help. She finishes her vegan crackers and cries a puddle of tears. She gives you her entire piggy bank. It's a very thick piggy bank, and pleads with you to save Patty. Well, now you have a new prospective client. You have Mandy, and she's asking you for an administrative remedy. As you review the statutes, the rules, and the case law and the public records requests, you realize that commission is implementing potentially an unpromulgated rule. Specifically, the commission is requiring a permit when a permit is not required under the law. Therefore, the commission has an obligation to change the law or follow through with rulemaking. So in this situation, you have a few options with how you can decide to work with Mandy's case. So Mandy has administrative remedies available to her. She has been given not a petition, but a charging document from the commission, which is stating that if she doesn't comply, that they will take Patty and they will euthanize her. So to object to these decisions, you have essentially three options. There are three types of administrative proceedings. There are formal proceedings, there are informal proceedings, and there are rule challenges. Formal proceedings are codified under 120.569 and 120.57 sub 1. They'll give you all the procedures for formal proceedings. Informal proceedings are codified under 125.7 sub 2. Both informal and formal proceedings are meant to object to an agency's action. When an agency decides to make an action, any individual who is substantially affected by the agency's action has the ability to petition for a redress. Under Rule 28-106.111, a party has 21 days from the time that they receive the charging document, the petition, or however the agency is going to provide notice of their agency action, to object to the agency action. To object to the agency action, they must file a written petition underneath the procedures of Rule 28-106 with the agency clerk for the agency that made the decision. So we have a division of administrative hearings. However, for formal and informal petitions, those are filed with the agency clerk, not with DOA. It is then the agency clerk that will take that filing and decide if there are either disputed issues of material fact or if there are no disputed issues of material fact. If the agency clerk determines that there are disputed issues of material fact within the petition, they will transfer the case to the Division of Administrative Hearings for the assignment of an administrative law judge, who will then convene a formal hearing to determine the disputed issues of material fact. If the clerk decides that there is no material facts in dispute, instead they may refer the case for an informal hearing. An informal hearing is very different from a formal hearing. In an informal hearing, there are no facts in material dispute. And further, an informal hearing is going to be presided upon by an employee of the agency, not an independent employee of the Division of Administrative Hearings. Now, that isn't to say that informal hearing officers are not independent and to the point are an informal hearing officer is going to be looking at the case to make sure that the law has been properly applied to the undisputed facts of the case. The agency has a lot of control under informal hearings, and in general, they're going to probably win because the agency is the one who is deciding what the law is. The informal hearing officer is really just more of a check to make sure that the law is being applied properly. And then the case is, once the case is decided, there is the option to appeal an informal hearing, just as you would an informal hearing under 120.68 with the district courts of appeal. Now, there is a third type of administrative hearing, and one that may be useful here in Mandy's case, and that is a rule challenge. Under 125.6, rule challenges are not filed with the agency. Rule challenges are filed directly with the Division of Administrative Hearings. Additionally, rule challenges are done at a very expedited schedule. In general, an administrative formal or informal proceeding will happen within 90 days of the petition. A rule challenge, however, will happen within 30 days of the petition. They are very quick. They generally have very short discovery deadlines. They're going to have a final hearing within 30 days, and you're going to have a decision on the rule challenge most likely within 60 days. Now, one of the reasons, though, you may want to find a rule challenge, if you can find one, is the fact that you can file a rule challenge directly with the Division of Administrative Hearings, therefore bypassing the agency formal or informal decision. If you believe that there are disputed issues of material fact, you will get to Division of Administrative Hearings with a formal petition. But if you aren't certain if there are disputed issues of material fact, but you do have a rule challenge, it may be a better idea to file the rule challenge. Proceedings at DOA can be consolidated. So if you do have a petition and a rule challenge, you can consolidate those proceedings. Additionally, in a formal or informal proceeding, you can use a invalid or an unpromulgated rule as a defense to an agency action. But it depends on whether you file the rule challenge independently or if you use it as a defense, which may define where you have your challenge heard. If it's just as a defense and it's an informal hearing, that could be potentially heard only by the agency attorney. If it is a rule challenge, then you have the option of going to an independent division ALJ to make the decision. So make sure to determine what you have when you're considering which forum to send your administrative petition to, and consider whether you have material facts in dispute. I think here we have a material fact in dispute. They say that there is a snake, or that they say that Patty the Python is a non-native species. We say that she's not a non-native species. We believe that is a factual dispute. It's not an interpretation of law. We're not saying that there are 5 different snakes and this particular breed is underneath a conclusion of law. We're saying we don't think factually this creature is covered by this rule. And so we have a factual disagreement. So I think we have the option of a rule challenge and potentially a formal petition in this case. And I would suggest filing both, because if the agency decides to go the informal route, you still have the rule challenge, and it may push the agency to sending the formal petition to DOA so that those cases can be consolidated and resolved at one time.
Excellent. Thank you so much, Brad. We sincerely appreciate it. I know that if Mandy were real and Patty the Python were real, they would thank you too, and be very excited to defend their position before the Division of Administrative Hearings.
Justice for
Definitely.
Patty.
Yes, justice for Patty. At this time, we'll have Q&A.
All right, so You can use the chat or the Q&A feature to drop any questions. Let me see if there are any pending in the Q&A. Opening it up. I don't see any pending, but as they come in, I'm going to start dropping some additional information in the chat. I'm going to start with, I copied and pasted way too much. So I'm actually going to start with the materials, even though I had already dropped the materials in there. In the materials, you're going to find the copy of the slides. You're going to find a copy of the bios, and you're going to find the CLE. I will also upload a poster with information about all the CLEs and the next upcoming segment. And speaking of, I will also drop here the page that I'm keeping up for the entire series. It's in the public interest law section website, but I mentioned it earlier in the chat. Feel free to bookmark that link and share it with others that may have not had the opportunity to necessarily register for the first few segments. In that page, you're going to find the recordings for the first two segments. Once we're done processing this one, I'll go ahead and update that one as well. And when we're done with the last segment, I'll make sure to update that one as well. That's why I recommend you bookmark it so you can find it all in there. So the other quick announcement that I have is the CLE code. Let me actually have it here ready to go. So I can drop it in here. The CLE code is 2600950N as in Nancy. And as I mentioned earlier, we have multiple CLE credits. I think the point 0.5 for ethics and point 0.5 for professionalism will very well earn with that ethics question. And that's one of the things that I enjoy about these segments. They're interactive and they really make you think. It feels like a bar exam where you always have two answers that are probably the best options, but I like those challenging interactive questions. So the CLE code will also go out via email. I will also include it in the YouTube description, as well as the materials. And the next segment is not next week. We're skipping 1 week. The next segment is going to be, I'll give you the exact date. It's going to be Tuesday, March 31st. I'm going to drop the link for you to register. Here's the date. I'm going to drop the link for you to register right now in the chat. But be on the lookout. I will also include all this information in the email in case you cannot access that link right now. So let's see if there are any pending questions in the chat. I don't see any in the chat. I don't see any in the Q&A. So
Well, before we go, I just want to give a special thank you again to Brad for co-presenting this particular segment with me. I sincerely appreciate it. We had numerous conversations about what we were going to do for the unpromulgated rule, and I was convinced that we had to do something to help Mandy Magpie because her story can't just end with the incident at Marshland Academy and poor Mr. Swamps. We'll continue to hear from him even into segment 4 of the CLE series. But I just want to impress to the folks that are attending that if you use the advocacy strategy and you just do that analysis, you'll realize that you have numerous options available to you to try to attack the issue. And we have to start thinking a little more globally and how we're going to attack these things if we're going to be more effective. I promise you that organizations and entities, they attack every issue that they have from a very global perspective to the point of going into states and getting legislation pushed through that makes them immune to any litigation. They'll do that. They do all kinds of things, but they're always being proactive, and often we're kind of picking up the pieces in a scenario where a client was reactive. So we have the ability to be proactive. We have the ability to attack that same issue from any number of fronts. And as we talked about in segment 2 with intentional and unintentional test cases, like with the Accutane, not having the warning, right? That someone may become suicidal or get depression, but now it does come with that warning. The folks brought that before a congressional hearing. Normally, if that gets to an attorney, they're thinking about a class action, right? Do both. Find out what entity, an organization provides oversight of this person or their business or their practices, and also see what remedies are available there. I Segment 4 is about adversarial collaboration, and we're going to talk about it. And I'm more on the touchy-feely side. But if it doesn't resolve, understand I'm coming from every possible angle. There will be multiple lawsuits, and I will be the common denominator as co-counsel. There's going to be the hearing. It doesn't have to be a congressional hearing. If you need it to be, it can be that state legislature looking at this. All of these things create push and pull factors. And I prefer to resolve things hand in hand, as I have done most of my legal career, in as much as possible, and still advocate on behalf of my client zealously. But if you have to actually pursue this, and you need those push and pull factors to exist, do that analysis and you'll see that it will take you very far in trying to resolve it. And if you didn't think that you were going to get the outcome you needed from the Florida Supreme Court, guess what? You got to hop over to the legislature, who was actually looking at the legislative intent of 443 and not an unknown application of 440 to an entirely different chapter, to actually come out with something that is consistent with what should have happened in Mr. Swamp's case. So I hope this information was helpful. We appreciate you joining us. A special thank you to the Public Interest Law section, the Administrative Law section of Florida Bar pals coming together to co-sponsor this along with the Florida Legal Services Statewide Training Initiative. We appreciate you, Jorge. You rock, doing all the logistics, making sure this happens. And we're super glad that you guys get all of these CLE credits. Yes, if you do all 4, it's all there. You get 2 hours of ethics. You get 2 hours of professionalism. It's awesome. So we'll look forward to seeing you guys in segment 4.
I did
Thank
see
you,
one
Vi.
question come through before we wrap up. I think we have a few minutes left, so I wanted to give the opportunity to address this question. And the question that came in is, what is the implication that an unpromulgated rule by FWC may be governed by their constitutional authority?
Okay, so excuse me. This is an interesting one. So if a rule is based upon the agency's constitutional authority, it still could to potentially be an unpromulgated rule. It depends a little bit more. You're going to have to do a little bit more analysis on that and figure out sort of where the lines are. But there could be some elements where it wouldn't necessarily be a rule if they're following purely upon their constitutional authority. But you really do have to sort of peel out the layers of the onion when you're dealing with that kind of issue. One thing I would say is that previously, some agencies were not completely part of the Administrative Procedures Act. I think the Department of Health was the last one to join when they got the Office of Medical Marijuana Use. But previous to that, the constitutional authority can be a sticking point on some of these cases. So definitely, it could be an issue. I don't have a yes or no answer for you because it really depends on how the constitutional issue is being used. Is it a statute that's truly the basis? Could we find something else that could be wrong with it? You're always going to be asking these questions. But before I give up the mic, thank you, Vi, for putting this all together. This has been amazing. I thank you for inviting me. I've had a great time, and I think this is a great thing for every, not just attorney, but every individual to learn to be more strategic with their advocacy.
Awesome. Thank you so much, Brad. And thank you again, Jorge. Much, much appreciated.
All right, thank you both for leading this amazing webinar. Thank you, everybody that joined us, and we'll see everybody else at the next one. Have a great rest of your day.
Thank you.